sure that you understand. And when I get to a point in my colloquy, suddenly you don't understand. I thought that today, by using the state form, that it would make it that much easier, that you would have it in writing in front of you, and that we could very quickly go over it again.
Well, I'm sorry, but state forms don't really mean anything. I mean, I've been presented with state forms that's improperly sworn, unfiled, and all that. So, I mean, just because it's a state form, I don't really trust anything that's handed to me by these courts. So I'm not
It's a form, Mr. Barker, that just sets forth what your rights are. Again, you have a right to be represented. You also have a right to represent yourself. You've made it abundantly clear with the appointment of numerous public defenders and with the retention of your own lawyers representing you, that you know what lawyers do. You know the advantages and disadvantages of having a lawyer represent you. I just need to make sure that you understand this penalty portion.
Okay, but I'm just not signing it. That's just the bottom line.
All right, I guess what I'm going to do, let me just finish going over the form with you, just so that the record is clear that I've gone over it with you. I will correct your age. I need you to look at the middle portion of the page, sir, where it just details the crimes and penalties. In count 1, you are charged with conspiracy to commit felony theft of movable property in an amount greater than $10,000 as a repeater, a crime which subjects you to a $25,000 fine, 14 years in prison, or both. Count 2 is possession of THC as a second and subsequent offense as a repeater, a crime which subjects you to a $10,000 fine, 7.5 years in prison, or both. And in count 3, you are charged with possession of drug paraphernalia as a repeater, a crime which subjects you to a $500 fine, 2 years in prison, or both. Do you see that on the form?
I'm looking at the form, just again.
All right. Do you have any questions about the crimes, the maximum fines, or the maximum penalties?
No, I don't.
And what is it, Mr. Barker, that you don't understand?
I don't understand how this so-called justice system can drag somebody, a family man, in and out of court every month, knowing that they don't have the proper evidence to even try to proceed with this, knowing that.
Mr. Barker, the crimes, the maximum fines, the maximum penalties are set forth now in writing. I understand that you disagree and that based on your motion to dismiss, you think all of these charges should be dismissed. That's your opinion and you're entitled to that opinion. My question to you is, do you understand what you're charged with? Yes or no?
I don't know what I understand right now. I definitely don't understand what's going on in this courtroom.
I'm beginning to question your competency, Mr. Barker, and I'm wondering if an evaluation might be necessary.
Well, like I said, I came with my motion, I'm prepared to argue, but I'm just not signing anything. That's just the bottom line.
Ms. Johnson?
Your Honor, I had emailed the same form to the defendant, so he's been aware of this form. I had wanted him to sign it before I communicated with him. So certainly he's had an opportunity to view, if not this form, a similar form. I think he's being difficult, but he himself has said he's not competent, so perhaps an evaluation would be necessary. I have no objection to the court appointing standby counsel. I have concerns that the defendant will continue to be difficult with those attorneys as well.
Honestly, I don't know that the Public Defender's Office, Mr. Barker, will even appoint someone for you. This is what I'm going to do today. We are not going to hear your motion to dismiss based on potential competency issues. So I will do two things. First, I'm going to order a competency examination. I will forward your case to the Public Defender's Office to see if they will appoint someone to represent you as standby counsel.
That's all I need.
And we can schedule this for a review of your competency and status of a standby attorney in 30 days.
Can I address the court?
On what, sir?
Well, the DA is steady stating that I'm being difficult. It's been 2.5 years, and I've been requesting discovery.
Okay, we're not even going to get into the merits, sir, given the fact that I do have to question your competency to proceed today. So
Okay.
date 30 days for a competency evaluation and standby counsel.
October 23rd at 3.
Ms. Johnson, does that date work for you?
That date does not, if we could avoid Mondays and Tuesdays.
November 3rd at 1:30.
Do you have anything later that day?
3.
That would work.
November 3rd at 3. Does that work for you, Mr. Barker?
I don't look like I have a choice in any of this.
Do you have any other appointments scheduled that day?
I gotta base my life around this case. It's been like that for 2.5 years now.
All right, I will take that as a yes, November 3rd at 3 p.m. If you wouldn't mind handing that form to my court officer, if you wouldn't mind, Bill, picking that up when Mr. Barker comes back, we will try that again.
And Your Honor, for that appearance, may I appear by phone?
You may appear by phone.
May I appear by phone as well?
No, sir, you will need to appear in person. November 3rd at 3 p.m., you will need to cooperate with the competency evaluation, and you will need to cooperate in with anything the public defender's office may need to appoint standby counsel for you.
So what is the competency? What is this? I mean, I want somebody to call me or something?
Yes, they will be contacting you to schedule an appointment, sir.
Would you prefer if I call in, or would you prefer to call?
I'll call you.
Oh, do you have the phone number?
That's number to contact you that day?
Yes, 262-741-71.
Okay.
Mike, what? Guess we're good. Nothing else, Judge?
No, that's it for today.
Well. Walking up. That's good. Some documentary.
Hello.
When did we schedule this for? I'm sorry, November?
November 3rd.
First one?
At 3.
Sure.
So,